Good afternoon. This is Jennifer Carroll, and I want to welcome you to another edition of Florida Appeals Journal. We're back on track. I'm going to try to keep you up to date on certain issues, certain cases that can be relevant to your practice. If you're a layperson and non-lawyer, get you educated on what's going on in the court system, state and federal. Today, I want to talk about a case I recently had. It's the Watts case versus a homeowner association, 133 F 4th. That's Federal Reporter 4th, 1032, 11th Circuit, 2025. And that's a really interesting case. The 11th Circuit took over a year to get its opinion out to us. That case involved really the question of what rights does a homeowner have within the homeowners association, especially when it comes to discrimination, civil rights, and you don't have a lot of cases on that. So I think they made some very specific law in this case, and that's going to be relevant to a lot of folks. In that case, the plaintiff, she lived in a homeowners association in a development with her family. She sued the HOA, asserting that she was treated unfairly. She was treated differently because of her race. She claimed that the HOA harassed her, restricted her use of the neighborhood amenities, enforced rules against her that did not apply to white residents. And they made her living situation so unbearable, she had to move, and she even became temporarily homeless. Now, this is what was alleged in her complaint, and in the lower court, it got dismissed with prejudice. Okay, so it went up to the 11th Circuit just on that small record, and the question was, did she state a valid cause of action under certain key statutes? She claimed first that the HOA broke federal civil rights laws, including the Fair Housing Act and the Civil Rights Act, because they discriminated against her after she had bought her home. So the main question in the case was whether these laws, the Federal Fair Housing Act and the Federal Civil Rights Act, do they protect people from discrimination that happens after they move in, not just when they're buying or renting a home? Because most of the cases out there have interpreted the statute to apply only when they're buying or renting, but not for activities that occurred after they're already in the home. That's why this case, I believe, is very significant. The trial court dismissed Watts' case. It ruled that the FHA only applied to problems during the sale or the rental process and not afterward. And that I think is why the 11th Circuit took the case and gave oral argument and rendered a very lengthy opinion on it. Now, the court ruled in Watts' favor, sent it back down to the trial court to go forward. She can go forward with her litigation. The Fair Housing Act in Section 3604B, that was the main statute that was interpreted in that case. And that part of the statute makes it illegal to treat someone unfairly based on race in terms of housing conditions or services. The 11th Circuit specifically found that the protection of that statute does not stop after someone buys a home, and it covers how they're treated while they live in that home. While she's living there, the plaintiff had to follow HOA rules as part of owning her home. The HOA allegedly denied her equal access to the amenities in the development, unfairly enforced parking and pet rules, and imposed fees in ways that were harsher than what white neighbors experienced. Now, these are allegations in the complaint. They still have to be proven at trial. But what the 11th Circuit held is that that's enough to state a cause of action under the statute. And that's a big deal. So the appellate court found that these are, quote, terms, conditions, or privileges of home ownership, and it's covered under the Fair Housing Act. And they said 3617, that statute bans harassment or interference with someone's housing rights. So since the plaintiff had made valid claims under Section 3604B. The 11th Circuit said she also had a valid claim under Section 3617. They also addressed 42 U.S.C. Section 1981, which is the Civil Rights Act. And that statute protects equal rights to make and enforce contracts regardless of race. The plaintiff had a contract with the HOA through the community rules that she had to follow. And she claimed in her complaint that the HOA breached that contract by treating her differently from the white homeowners. And the court ruled that she provided enough facts to support her claim under the law. Then it also, under the Civil Rights Act, Section 1982, that statute, broad brush statute, gives all citizens equal rights to use and enjoy the property. And the plaintiff claims were consistent with the HOA did not allow her to use the amenities or enjoy her property equally. Again, the 11th Circuit found that these type of allegations did support a cause of action to support Section 1982 claim under that statute, the Civil Rights Act. So I would recommend you take a look at this. It's a very enlightening opinion, very detailed and very relevant to homeowners living in homeowners associations, which we have a lot of folks doing that. That's our issue for today. The case I wanted to update you that came out in just this year, 2025. And as usual, any questions, go ahead and send them to us and we'll do our best to get to them. Thank you again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.